Somebody has deposited a helpful document on our...
Not me, mercifully.
Lady, I'm sorry, that was us. I indicated to my lady, Lady Black,
Thank
that
you very
would be
much.
provided. It's pages 8 and 16 are the relevant pages.
I'm about to chide you, Sir James, by saying I look forward to the afternoon coming here. There isn't some new document here on my desk. But you're entirely guiltless.
Within the
guiltless.
four corners and guiltless, as usual.
And we were to blame for this. Yes, we asked for it, so...
Just before restarting, can I just invite you to note, firstly, the correctness of my lady's observation about the comparison between 286 of Rantsef and 116, second subpara of Osman. But having given you that, can I take some of it back by referring you to...
You always do, Sir James.
by referring you to the footnote to which the European Court saw fit to attach to the relevant sentence in paragraph 286 in Rantsef. And the relevant footnote is 105, which says, "Si mutatis mutandis, Osman."
Yes, I noticed
116 to 117.
And they also had mutatis mutandis references to Edwards in another paragraph.
Yes, I think that there it's Osman and Mohammed Kaya, but so my submission is that they are in essence replicating. My second submission was that, as you'll recall, that as Rantsef indicates, Palermo, ATC and other international instruments can be taken into account under the Demir principle in the formulation of the duties in the usual ways. But my core point is that they have done so for the purpose of developing the principles and identifying the mirror duties that you see reflected in those paragraphs 284 and following of Rantsef. And those uses, and indeed the uses of ATC in the subsequent case law, we respectfully submit, are a very far cry from saying that you simply transpose or import the duties from the ATC into Article 4. Indeed, one can illustrate that you don't do that by referring to some of the other international instruments. They've never done it that way, and they never do it that way. So they haven't said in relation to Palermo, all the things dealt with by Palermo are automatically transposed over. That simply isn't their technique.
Well, I think in fairness, Mr. Koppel doesn't argue that they should be transposed.
My lord, he doesn't, but to some extent you've got ships passing in the night here.
Yeah, well, that's why we're wondering whether we might throw some light on the point of passage.
I'm going to try and do that, but the ships passing in the night, one ship has on its prow, ED only says definitional, which is inaccurate, and the other one on my ship perhaps says Koppel imports far too much, if not all, which he says is inaccurate. So it goes back to my Lord Briggs's question, what's the standard by which you sort out the bits in the middle, which may take you to my lady's concern mentioned at the very beginning of this hearing, which is one might be very cautious about doing that as a court in an area such as this without concrete facts to shape that particular argument.
Or at any rate, facts where the outcome of the argument will make a difference to the position.
Quite so. But I've got something to say at least about the degree of importation which my learned friend Mr. Koppel identifies. But as you will now see, we're not just saying you use it for definitional. They use international instruments in the ordinary way, applying the Demir principle. The question is how far that goes. And my essential answer, I come back to it, my essential answer is they've taken all those other international obligations and instruments into account, particularly and primarily for the purpose of shaping those well-established mirror duties. And so in answer to the question, what is the principled approach that this court or Strasbourg would apply? Answer, see Rantsef in those paragraphs, and when you go to all the subsequent case law under the section saying general principles, you get Rantsef repeated and then they're simply applied.
But when you work it out in practice, if you're doing a real case, you might need to have reference to the other convention, the Anti-Trafficking Convention, in order to, let's suppose in an investigation case, someone says, you haven't investigated, the response is, yes, we have. The answer is no, because we needed a period of rest and reflection, see the Anti-Trafficking Convention.
My lady, there are circumstances, and I'll come to them, there are circumstances in which we accept that in certain circumstances the European Court would be likely to, and indeed has, looked at those things. I mean, for it to
But the domestic court might look at it.
Yes, of course.
And you're not objecting to that. I'm finding it really difficult to know where you're disagreeing.
Yeah. Well, my lady, there may be very little between us in terms of the overarching approach. We're simply not saying this is purely definitional, but we are concerned that that a court doesn't just, particularly when we come to removal decision and that aspect of it and what that brings to the party, which I'll come to, but we're very concerned that the court shouldn't start giving a judgment that effectively says they are to be taken, that is, the obligations under the ATC are to be taken as an inherent and integral part of, or most of them, as part of...
Mr. Koppel was asked, are you saying a breach of that convention is a breach of Article 4? And he said no.
No. Well,
so you've common ground on that.
We've got common ground on that. The question then is extent. And we do respectfully agree with my lady. There may be some concern about doing that. As I say, the yardstick still remains. Apply Osman if you're considering operational duty, or its equivalent in RANSEF. Apply when you're looking at the framework, the usual approach that you would see under A2 and A3. There can't be a good reason for a really significant difference in terms of either importation of international obligations or anything else between A2, A3 and A4. They're all treated in essentially the same way by the Strasbourg court. And so my respectful submission is that the subsequent case law has not, in truth, extended the principled approach that you see from RANSEF. That's the third submission. And when you go to those cases, to those subsequent cases, you find those principles simply repeated in the general principles section, and then they're applied in various different ways. Sometimes, as my lady rightly points out, by looking at the ATC, taking some of it into account. But there is no suggestion that when you come to, for example, the positive operational obligation that may apply in certain circumstances, you do anything other than apply the Osman approach. So in Chowdhury and Greece, that was exactly what they did. I'm not going to go back to it unless you wish me to. It's in Bundle 1, Tab 9, and the key paragraphs are 86 and following. And the points that we would invite you to note in relation to Chowdhury and Greece are firstly at 103 and also 87 to 89, that's the paragraph numbers. They emphasise that the protective obligation would be breached. So I'm dealing with the protective operational obligation would be breached only where the member state failed to remove an individual from risk. And again, you saw that in RANSEF. That's the prime purpose of that operational obligation. And the comment at 104, when dealing with that my learned friend placed considerable reliance upon, all that indicates, we respectfully submit, is that the court was guided by the ATC, followed immediately by the court statement of the obligations as per RANSEF. So they took it into account and they got to the mirror position.
Have you got a page reference? Just for my note.
103.
104, let me give it. Forgive me. It's 213, sorry.
Thank you.
Someone already said that. 213. So you see, all that's saying is that the member states' positive obligations have got to be guided by the ATC. Well, the answer to that is they have been. That's what they were. That's what they were doing in RANSEF. The cloth is coming, my ladies.
Thank you. It's a long time since I've done that.
So there's no great significance to be attached to that paragraph. It's simply indicating that in shaping the positive obligations, they look at the ATC. They did that, they created the mirror principle. And there's been no concerted suggestion, I think, that in relation to the protective obligation, anything in Chowdhury takes matters any further. There's no translation, if one focuses on 110 of Chowdhury, on page 214, there's no suggestion or indication as to where the reference to assisting the victims in their physical and psychological and social recovery comes from in the jurisprudence. But more importantly, there's no translation into a finding on the facts, or even consideration of it against the facts of the case. It simply wasn't in issue. There was there a breach of the protective obligation, the Osman obligation, because the authorities knew about the position in the strawberry fields and did little or nothing to resolve it or deal with it. That's the reasoning at 110 to 115. There's no breach found, or even consideration of finding a breach on the basis that they didn't find that there was support of the kind offered by the ATC. So the principle is that taken from Rantsef and referred to in the general principles section, if you go back in Chowdhury to 208 in the MS numbering, you see the section general principles above para 86. And so far as the protective obligation is concerned, the principle is the one that you're very familiar with from Osman/Rantsef in paragraph 88 on page 209. Remove the individual from that situation or risk. Not remove the individual from that situation or risk and then provide with all relevant support as per the ATC. And then in 121 of, still in Chowdhury, para 121 of Chowdhury, where there is another reference to the ATC, you'll see it's in a very specific context, and this may be an example of the point that my lady, Lady Black, was putting to me. They do refer to the ATC for this purpose, but here they're taking Article 13 of the ATC into account. I'm on para 127 on page 217. They're taking it into account in deciding the belatedness of the complaint issue, and whether there was a good reason or that provided a good reason for the lack of investigation in relation to those who complained late. And they drew on the regulatory framework in the ATC to point out that victims were recognised as needing a period of time to recover and couldn't therefore reasonably be expected to make an early complaint. But again, that's a very different thing from saying that therefore you have a positive duty under A4 to provide a recovery period, an RARP. They're simply taking it into account as part of the framework, as it were, for that very specific purpose of determining whether there was an excuse for the belated complaints being made. And the same points or sort of points can be made in relation to J and Austria. That's in tab 10 of the same bundle, page 224 and following. And again, the approach is exactly the same, which is to apply the principled approach, recognise that Rantsef set out mirror principles, and then simply to apply those principles, that principled approach, to the facts of the individual case. That's the third submission, therefore, that the subsequent case law has not moved the position in any material way in terms of the principled approach to be followed. And the fourth submission is that, and again, this may be a question of degree and extent rather than an absolute submission, but the suggestion that the protective obligation, i.e. the Osman-style obligation, includes all of the steps provided for, or even a significant number of the steps provided for under the ATC, as necessary and concomitant parts of the Article 4 obligation, would involve a very significant extension of Article 4 and of the ECHR generally, we submit. It isn't just some minor thing that says you can drag it in under the rubric of the Osmond-style obligation. A very significant extension because, as I've already indicated, Article 4 is designed to mirror Articles 2 and 3, and there's good reason of principle why it should do so, but do no more. One can illustrate the difficulties of Article 4 extending further, not least by pointing to the fact that in many cases, Article 4 ill treatment will also constitute Article 3 ill treatment. So why would you have a difference of approach between the two, quite apart from the hierarchical pedestal point I made before the short adjournment? And there's nowhere in any Article 3 case law any indication that, for example, if you're subjected to or might have been subjected to ill treatment, the state then owes you wide-ranging support obligations. True it is that Article 4 exists in a peculiarly anxious and serious context, but it isn't unique when the comparison that is made is against the range of ill treatment covered by Article 3. And my submission is that the operational steps and the operational duties in both contexts extends to, but only to, and centrally to, removal of the individual from the position of risk. The fifth submission is that we do respectfully submit that the Court of Appeal was correct in their approach to the issue that confronted them in Hoang. And can I invite the Court to go back to that? It's Bundle 1, Tab 8. I suspect that the Court will have had an opportunity to read this judgment anyway, so if I may, I'll just make some submissions about it. The issue in the case, it's important to bear in mind, was a pretty narrow one. The issue was whether or not a failure to follow the Secretary of State's guidance, in effect implementing the ATC, was ipso facto, and I underline ipso facto, was ipso facto a breach of Article 4 of the ECHR. And it is to be noted at the outset that it was common ground between the parties that if the judge or the learned deputy judge there had applied an approach that directly correlated breach of the guidelines with breach of Article 4, she would have been wrong to do so. See, for example, Mr. Westgate's concession to that effect, a correct concession, as the Court subsequently held, at paragraph 24. And the question that they were confronting was whether or not, the subsequent question was whether or not the judge had in fact approached the matter in that way. But, and the significance of the judgment is that the Court then considered whether or not that concession by Mr. Westgate was a proper concession. And it was in that context and for that purpose that the Court analysed with some considerable care and in some considerable detail the differences and the distinctions that existed between the ATC and its obligations and its aim and function on the one hand, and Article 4 ECHR on the other. And it does so in the course of its judgment, pointing up, for example, to take 4 examples and give you the paragraph references if I may. The Court pointed out that the procedural obligation under Article 4 is to investigate offences within the jurisdiction, subject, of course, to mutual legal assistance, which we saw referred to in Rantsef. Its obligation is simply to investigate offences that might have occurred here. That's a product of Article 1 of the ECHR. So not, going to the facts of that case, offences that might or might not have been committed in Russia. See paragraphs 28 and compare, which is what the court did, that position under the ECHR with what they described as the broader focus and remit of the ATC. See, for that comparative purpose, paras 32 and 40 of the court's judgment, where they pointed out, amongst other things, that the ATC has a broader purpose, and it could well be part of the state's function under the ATC to look at what may or may not have occurred in Russia, because that might go to whether or not someone had been trafficked. That's the first example. Second example, they pointed out that there were differences in relation to the procedural and investigative obligations and the scope of those. And they did so in particular at paragraphs 29 at the bottom of MS 175, which was the ECHR position, and para 30, which is the ATC position, as they there describe it, the ATC having, quote, a wider scope. They then pointed out in 31, which I think my friend Mr. Coppell took you to, that there are different UK bodies in relation to the investigative function. There are different UK bodies fulfilling different functions. And the competent authority is not, as they put it in the middle of that paragraph, the investigative body for the purpose of the alleged crime or subsequent prosecution. So there are differences at that level anyway. And then they point out at 36 to 37, to give you the final example, they point out that the triggers are different. And they do that in paras 36 and 37, noting that any suspicion will do under the ATC and the guidance, whereas under the ECHR it has to be, remember the words from Rantzef, a credible suspicion, which they consider to be at least close to the reasonable grounds decision that are made. And so it was on that basis that the court went on to conclude, correctly as we submit, under paragraph 34, that the ATC is not a surrogate for the procedural, and we would add, indeed, any of the other obligations under Article 4. And it was for that reason that they concluded that the concession had been correctly made. In other words, the concession that if you just treated the breach of the one as equivalent to a breach of the other, that would be an error of law. That was the basis on which this decision proceeded. And we respectfully submit that that is correct, and that was the correct approach. The ATC does indeed, as Lord Justice Burnett put it, have a wider scope. That's paragraph 30. So there are significant differences between the two, and considerable caution is to be urged, we submit. So the position as we submit it to be is that we have different obligations and systems, even if there is some degree of informing between the two, if I can put it that way. There is no necessary correlation between the duties under the one and the duties under the other. There is no dispute that the ATC can inform an Article 4 analysis. That is why, for example, and it's only an example, Article 4 was interpreted to include trafficking as defined in the ATC. But critically, the ATC is not a surrogate. It has very significant differences to Article 4, and there's absolutely nothing to show that specific obligations in the ATC are simply or presumptively even to be treated as being part of the positive obligations on the state under Article 4. And so the fundamental position as we submit it to be is that yes, the ATC has been taken into account in shaping the Article 4 principles, but the Article 4 principles are mirror principles with Articles 2 and 3, and they're very well known. So you simply apply those principles to the facts of the particular case.
Would you quarrel with the proposition that the ATC informs the content of Article 4?
my lord, I'm not sure I would quibble with it that way. I don't want to be, as it were, trapped into accepting that.
I would never dream of doing
My
that.
lord, long and bitter experience, I'd be tempted to. but my lord, it can inform. We've seen a variety of ways in which that can happen. I'm perfectly prepared to take my stand on the Demir approach as informing. My fundamental point, however, is that it's already happened in the formulation of the principles which are reflective of very well-established principles under 2 and 3.
It's just a little difficult to get a handle on what the tangible impact or effect of informing the content is. You know, what is it doing? If it's not requiring the rest and reflection requirement, what is it doing? How does it inform the content?
Well, my lord, I suspect that that's not a unique problem to our context, is it?
No, of course not. But
there are lots of international conventions which they rely upon a whole variety of different contexts, and what they tend to do is pick and choose, as it were, when it suits their judgmental purpose on the facts of an individual case. Is probably the honest answer to that. It doesn't provide a terribly analytical framework for doing it, but at least here you have the. I respectfully submit the real benefit that no one has ever said, well, when you get to the Osmond duty, you need more, because it's jolly difficult to understand how it really works in practice when you try and apply it to an individual case. You just apply the Osmond principles. It happens every day in inquests and inquiries, and when people say the state ought to have known and ought to have protected. There's no difficulty with that. And here exactly the same thing has happened. They haven't, as it were, created a big, broad space into which the other international instruments are necessary to fill the void. What they've done is to use them to support and bolster the mirror principle. And so that's where we invite you to end up.
Well, an interesting way of testing, I mean, your basic submissions, I understand it, is that the convention can be used as an explanation of why the positive duties identified in RANCEF are there, rather than as a build-out from them. But take, for example, the rather generally stated limitation on the duty that it mustn't impose a burdensome obligation on the state. Now, there it seems to me, but tell me if I'm wrong, that it's quite easy to see how the convention assists in going further there, because if a state has signed up to very specific obligations under the convention, it would ill lie in its mouth to turn up and say, well, that's disproportionately burdensome under that general RANCEF principle.
My lord, I don't think I disagree with that.
That's quite a granular way in which one might use the convention, albeit it might be used in more general ways in other circumstances.
It's possible. I mean, but the way you put it would lead to a tolerably limited importation of the ATC obligations.
Yes,
it would do so because it would not, as you put it, lie in the mouth of the state to say.
I'm not using those words, but
no.
Yes.
But it would not lie in the mouth of the state to say something was disproportionate when it had signed up to do it in the left-hand corner of the international scheme. And so we wouldn't have any great difficulty with that. But as I say, what we are confronting, whatever the difference of degree between my learned friend and I suspect it may be a great deal less than has previously been perceived, but whatever the precise extent of that difference, there is at least some practical impact, because you go through the case and almost every one of the ATC obligations my learned friend seeks to drag in by way of analogue, even if he recognises that some exceptions exist. And we respectfully submit that that isn't the right approach, and that you should start from the position where, unless you can get in through that sort of door, the game has already been played, and the result of the game is Osman and framework and all the well-known 4 obligations that I identified. That's all I wanted to say about the approach in principle. I wanted to turn next, if I may, to the application in the present case involving, as it does, a challenge to a removal decision. And the core and central point we make in relation to this is that this is an immigration appeal. And Article 4 we submit is irrelevant only into the extent that removal of MS would breach his Article 4 rights. And indeed, an immigration appellate tribunal has no jurisdiction. It is no part of its function simply to conduct a review of the kind that might be made in a JR as to whether, in all respects, the state complied with whatever public law obligations it has effectively under the ATC. The trafficking decision must be relevant to the decision to remove, for that to be relevant to that appellate structure. And so the first question, it might be thought, is whether removal would breach the protective obligation. That is the Osmond-style obligation. And my submission is the same one, which is that the position on that obligation is the same under Article 2 and Article 3 and Article 4. And it would do so, therefore, only if there were substantial grounds for believing that there was a real risk of the person being trafficked. That would be the position under Article 3, with ill treatment put in place of trafficked. And it is the position under Article 4. And the significance of that, of course, is that you have here a positive finding, which no one seeks to go behind, by the upper tribunal, that he was not at risk of being trafficked on removal. I can take that from paragraphs 44 and 45 of the Court of Appeal's judgment, quoting the relevant bit of the upper tribunal's judgment, and that is at page 2376 in the electronic, paragraph 44.
Well, it's paragraph 66 of the
It is.
upper tribunal
It is.
on page 2421.
It is. But the reason I was taking you to the Court of Appeal judgment is because they go on, you can probably get it from 67 of the upper tribunal, if that's where you prefer, to say that the same point undermines the protection claim, also fatally undermined by the availability of safe internal relocation. But they specifically and positively reject the idea that there's any risk of re-trafficking, or indeed that there's any current position of risk and exploitation even in the UK. And that, we respectfully submit, is the end of any suggestion that there would be a breach of Article 4 in terms of the protective obligation. There is no continuing risk on the uncontested findings of fact made by the upper tribunal. So the question then is, in relation to the protective obligation, well, what about historic breaches of duties provided for in the ATC? And our answer to that is, firstly, that any such historic breaches would not render removal contrary to Article 4 for the principled reasons I've given. You can't just transpose over from the ATC and say, ergo, breach of Article 4, Court of Appeal in Hoang, right. Secondly, historic breaches in the face of that finding at para 66 of the upper tribunal's judgment have no impact on the removal decision. And at this stage, it's right to acknowledge, as my learned friend Mr. Coppell fairly did in exchanges with Lady Black, I think, that in relation to the ECHR issues, it's as at the date of the upper tribunal. And so our position is, our submission is, that the removal issues and the domestic public law obligations flowing from the ATC are distinct, and they need to be kept so. So if, for example, he objected to a reasonable grounds decision and that meant that consequentially he wasn't in the game for the support under 12 and 13 of the ATC, then, as a number of the cases in the bundles demonstrate, he can go off to a JR in court and complain about that. But they are separate, and one needs to be very careful to analyse clearly the nature of the jurisdiction, conditioned as it is by the relevance of the particular asserted breach to removal of the tribunal structure. And that is the position in relation to Article 4, that you should decide it on the basis of the facts as they currently are, rather than on the basis of historic breaches, if any, directly mirrors and echoes the position which this court laid down, I think overturning a line of authority which might have suggested something different, in the context of asylum, in the TN for Nanny Afghanistan case. I don't invite you to turn it up, but the relevant reference is bundle 3 of the authorities, tab 42, and the relevant paragraphs are paragraphs 70 to 72 at MS 132 to 1321. What then if he was removed when he should have had an RARP, arrest and recovery period? My first submission in relation to that possibility is that that would go well beyond the limits of Article 4. There's no right under Article 4 to have the support of the kind set out in the ATC. Secondly, not in any event connected to removal. The failure, if there is one in that sort of situation, is under the ATC with the ability to challenge in a JR, as is regularly done. And here, at the time of the upper tribunal decision, not merely did you have the finding at paragraph 66, which you've already seen, but the date for affording any such RARP had long passed, as it was put by the upper tribunal at paragraph 59 of their judgment. The loss of benefit was irreparable. And indeed, it might be thought that the purpose for which it existed at that point of the upper tribunal's consideration, the purpose for which that had existed was no longer live, even if it ever had been. He'd recovered from the experiences, escaped the family members, and wasn't at risk. The same point arises in relation to, or set of points arises in relation to the suggestion and the upper tribunal's conclusion that he would have been granted a residence permit, or could have been granted a residence permit. My submission in relation to that, a separate submission in relation to that, is that a permit is only granted and necessary to be granted if it would allow, it's necessary to allow the victim to remain in the country on Article 4 grounds. And that simply isn't the position here in circumstances where he is not at risk at the date of the upper tribunal's consideration. It must be removal that would be the breach of Article 4. Historic breaches don't cut it for present purposes. So I think there was some suggestion by Mr. Hussain in his submissions that, well, you may be able to take historic breaches into account for the purpose of Article 8. But the short answer to that in this case is that that is there's still a current issue under Article 4, and it has to be addressed as a current issue under Article 4. There was no issue about Article 8, no live issue about Article 8 in this case. The upper tribunal didn't find there was any breach of any article other than 4, and there's been no appeal by MS on that basis.
Could you just help me about the basis of the appeal to the upper tribunal here, please? There are 3 possible subsections of 84, section 84(1). One's relating to the decision being unlawful under the Human Rights Act.
Yep.
One's relating to the removal being unlawful under the Human Rights Act. And one is the decision otherwise not being in accordance with the law. Yeah. They're slightly different in their drafting, and I'm conscious that all of this is gone now. And so getting into a learned exegesis about it is probably not going to help anybody. But do you know which of them it was?
I think it was. I think the ones that we've been focusing the argument on, at least I hope correctly, are the removal, the actual removal decision,
yeah,
on which its upper tribunal considers it as at the date that they're considering it, and then the in accordance with law one, which does take you back to the decision itself, the decision to remove, which may be earlier in point of time.
That means that decision means 2 different things in that subsection then.
It does appear to mean that,
but maybe not, because if you're under G, that doesn't happen.
I can.
Anyway, there you are. I'll leave that with you.
I can see. Can someone? Will you, if I've got that wrong, will you just write me something short? As I say, I think we're pretty much agreed as to the basic nature of the approach.
Yes.
Upper tribunal focuses on removal being a breach of Article 4 or not at the date on which it considers it. You have to go back on in accordance with law to do a slightly different analytical exercise. It takes you back to the decision itself.
Yeah.
But again, there's common ground that what you have to do there is to identify a public law error for that purpose. Otherwise, it isn't not in accordance with law, and that takes you into all the cyclone and the complexities of the tribunal having to assess the facts for itself and so on, and how that relates.
They never got that far in this case because they said breach of investigative duty under Article 4, so it's the human,
They did.
one of the human rights paragraphs.
They did, and the critical point for present purposes is, in doing that exercise in relation to ECHR breach or not, in the context of a removal, the question is whether the removal itself at the date and on the evidence before the upper tribunal would breach.
It's looking forwards then.
It's looking forwards, or presently, if you will.
Yes.
It's a current issue as I describe it. But the point I was on was that there's no Article 8 game being played for present purposes. So my submission in relation to the protective obligation, and I'm deliberately taking them in turn, as it were, under Article 4, the submission in relation to the protective obligation is that the Court of Appeal in our case were correct at paragraphs 83 to 86 of their judgment on MS 2387 to 8, and specifically they were correct that the upper tribunal only had jurisdiction effectively to engage on issues that were relevant to the decision that they had to and had the power to make, namely removal decision and whether in summary it would breach, as at that date, the ECHR rights that he has. Doesn't mean that the trafficking decision earlier on might not be relevant, or issues to do with that might not be relevant to the removal decision. For example, that a victim in the past, that he was a victim in the past, might support the proposition that he was at real risk of trafficking now. But those sort of theoretical possibilities don't arise here because of the clear finding the upper tribunal made at paragraph 66. The Court of Appeal were also correct to reject the proposition that if there was a breach of the ATC, that automatically led to a conclusion of breach of Article 4. That's simply a non sequitur for all the reasons given by the Court of Appeal in Hoang. To which one can add that even if some of those obligations under the ATC might be positive obligations under Article 4, and even if they were breached, it still wouldn't follow necessarily that removal would be in breach. So you could say, well, the Article 12 RARP is indeed a part of the positive obligations under Article 4 in some way, shape or form, and they were breached. But that still wouldn't lead to the conclusion that the removal decision was a breach of Article 4, because for that purpose you have to establish that it's the actual removal that would breach the Article 4 rights. So the second aspect of examination is whether or not any removal would breach the investigative obligation on the state as established by RANCEF. And again, one can envisage a situation, a theoretical situation in which it might do so, but it would be a relatively unusual case, we submit, because an immigration tribunal is not the proper forum for an examination of the state's investigative obligation, and it can't sensibly be said to be an obligation on the Secretary of State for the Home Department to consult with the police, for example, before taking a removal decision where there'd been an allegation or a suggestion of trafficking. So this is an issue, we submit, which would need to be specifically raised by an appellant. Otherwise, one runs into the difficulty that effectively the Secretary of State is obliged to start chasing shadows, as it was put in one case. And this issue was not identified as an issue in the agreed list of issues before the upper tribunal. See our case at paragraph 63. But the key point is that in principle, a breach of the investigative obligation would only occur where the act of removal would prevent the state from fulfilling an effective investigation. Here, probably criminal investigation, in most cases a criminal investigation. Point one. Point two, that is a current question, as I keep describing it. It isn't established by suggesting that the state may not have effectively investigated in the past. If that has occurred, it's unfortunate, but so be it. It doesn't affect the question of whether a removal would do so. And thirdly, that current issue must be determined on the facts. For example, if there were an ongoing prosecution, it could, in theory, breach an appellant's Article 4 rights to remove him if it was essential for him to remain. But it can't be a breach simply because a tribunal concludes that an inadequate investigation must have been carried out without any particular evidential foundation. And our basic submission on the facts of this case is that the Court of Appeal were entitled to conclude, as they did, at paragraph 88 of their judgment. As I say, we don't exclude the possibility that the upper tribunal or an upper tribunal could engage with that issue, but in order to do so, it would have to raise the issue properly, or the issue would have to be raised, and it would then be the subject of engagement and, if necessary, evidence, including engagement with the police. And the fact of the matter is that there just simply wasn't engagement on that issue in the correct and appropriate manner that would enable the thing to be tried out. And in those circumstances, the Court of Appeal was entitled to say, well, you can't just go criticising the police, for example, if the police aren't even told they're being criticised and no one has raised the issue and the evidence hasn't been before them and they haven't intervened if they want to. All we know is that MS was willing to cooperate, perhaps even had been cooperating with the police. But it's a non sequitur to go from that place to say, well, that should have resulted in prosecution. The police would no doubt form their own view, for example, about the credibility of any allegation that was made by MS. So that leaves the question of not in accordance with law. I can turn to that. And I emphasise, sorry to keep banging the same drum, but the question is the removal decision not in accordance with law? The focus is on the removal decision, and it isn't a precondition to a lawful removal decision that all aspects of the prior trafficking decision were lawful. They may have nothing to do with removal. That's the first point. The second point is that public law error would be needed. That's common ground in terms of the approach. And we submit in relation to that it's a non sequitur to say that there's a public law error simply because the tribunal reaches a different view after its consideration of all the facts. And that is the flaw and the non sequitur in the only part of my learned friend Mr. Coppell's case that deals with this issue, which is paragraph 50 of his case at page 2314. the Court of Appeal concluded at paragraphs 75 to 76 of their judgment that there was no proper basis upon which the upper tribunal could decide or could have decided that the competent authority's trafficking decision was flawed on public law grounds. And again, we think MS has not appealed against that part of the decision, that aspect of the decision. And in those circumstances, that is the answer. Paragraph 75 to 76, Court of Appeal entitled to make that judgment and to reach that conclusion. My learned friend Mr. Coppell this morning sought to suggest for the first time, I think, that there were errors of analysis, and he pointed to paragraphs 55 to 56 of the upper tribunal's judgment for the purpose of supporting that submission. And our answer to it is the same one. Those were the very paragraphs considered by the Court of Appeal at paragraphs 75 to 76 of their judgment. And we stand or fall on those, but we do note that there was no appeal from MS on that aspect. So that is the position on in accordance with law or not in accordance with law. The court raised the question, I think my lady, the President, raised the question about overhang, possible overhang. How many of these are there? And as I understand the position, and I emphasise this is on instructions, but the position is this. The relevant date is the date of decision. It's, so it's 6/4/15. Those would be the things that were being challenged. That's when the new system comes in, 6th of April 2015. So they would have to have been, if I can put it non-formally, hanging around for some time to be still overhanging today. And that, it might be thought, is increasingly unlikely, although one can never say never to any of them. But unlikely because, as I understand it, the tribunal, which used to have a large backlog, has largely worked through that backlog. So we wouldn't anticipate, on my instructions, very many, if any, cases raising not in accordance with law to still be in place, therefore the issue being still one of large general importance, and that may be a comfort of the court or not. But that's a position on my instructions. That leaves only the question of the concession, on which my learned friend Mr. Jaffe made some submissions. And I think what he took issue with, or urged in his usual measured way, caution in relation to, was the, I think what he might have been implying was a sleight of hand, but I'm sure he wouldn't put it that way. But it's paragraph 65 of our case. It may be worth just going back briefly to that. And the reason for going back to that is because in the fourth line, second last word on the line, we've deliberately inserted the word proper, albeit giving proper consideration and weight to any previous decision of the defendant authority. And we did it that way because we recognise that it's effectively nothing to do with us what weight is to be given, but there is, we're aware, at least some case law about those sort of things, that sort of circumstance, what weight should or should not be given. The fundamental point is that it is, of course, for the tribunal to determine the relevant factual issues for itself, and there isn't a perversity threshold that has to be crossed, but the weight that is to be given will have to be determined by the tribunal taking a principled position to that. And I put it that way with the adjective in there, because when you go back, if you go back when you're trying to formulate or reformulate what the concession should look like, which was the brunt of his submissions, we would invite you to read Huang, including in particular paragraph 16 as well as the paragraphs to which my learned friend referred you, Bundle 1, Tab 4, MS 78, because that indicates that in certain circumstances there may well be scope for the Secretary of State's view to carry some weight. And we don't, as it were, want to start shutting doors on proper weight being given to the Secretary of State's views when proper weight is to be given in accordance with Hoang. But the fundamental point is that we are... My lady, sorry.
I'm sorry, are we talking about the Secretary of State's views? I thought we were talking about the national referral mechanisms.
The national referral mechanism, we are.
Which I don't think is the Secretary of State.
No, but
I know the Secretary of State is the responsible department, but
My lady, we are.
I doubt if are the decisions of the NRM taken in the name of the Secretary of State?
Well, I think they are technically part of him or her. But anyway, it may not matter. The short point is we are content with proper weight and whatever the court feels is proper weight. What I don't want to do is, as it were, to be accepting that it's minimal weight, which was the drive of my learned friend's submissions, if there may be circumstances of which I'm no doubt less aware than some in this court, where proper weight would need to be given. But this wasn't an attempt, as it were, to slip from under or to introduce some codicil which would return to haunt Mr. Jaffe. Would you just give me one moment just to check? I hope I'm going to translate this right. It's an answer to my Lady Black's question. I think the position is that, and maybe the sting of the point is that whether it's under 84.1c or it's under 84.1g, it matters not. The approach is to look at current facts for both, or either, if you will. And there is an authority that so establishes, which is MS Ivory Coast, in volume 2, tab 25, page 789, at paragraph 70. And so for all of those other ones, apart from the accordance with law, you look at current facts. I don't know whether that doesn't answer my lady's question.
It means there's two forms of decision in the section, but there we are.
Mr. Jaffe's submission was that the ultimate task for the upper tribunal was to decide whether the decision was right. Would you accept that?
Well, they've got to take their own judgment on the facts and then apply those facts to the law.
But the judgment that they make is whether the decision under challenge was right.
Yeah, it's not a public law challenge.
No.
So they find the facts, there's no perversity threshold, and then they decide whether there would or wouldn't be a breach of Article 4 if the person were to be removed. Hello, those are my submissions.
Thank you very much indeed, Sir James. I think you've been asked all the questions that anybody wants to ask. Ms. Smith. I don't think she wants to say anything. I did ask her, but she didn't.
Thank you, Lady. Just on that, on the point just raised by my Lord Kerr, we agree, of course, that the task for the tribunal is to ask itself whether the decision was correct. Can I just make one correction to some submissions of Sir James in relation to the question of weight in Huang. Paragraph 16 of Huang, which I think is the key paragraph, is about weight to be afforded in the proportionality judgment. That's MS page 78, where the Secretary of State has some expertise, and the courts will give some leeway, some degree of deference, whatever the expression is, to the Secretary of State's preferred view. But that's not a that isn't the same as his view or the view of his officials as to the facts. And a small factual point which also arose at that point of the submission. I understand from Mr. Butler, who's more familiar with these things than I am, that the people who staff the NRM are immigration officers.
Yes.
So are the Secretary of State for all intents and purposes. Can I then go back to the core submission of Sir James regarding the relationship between the Anti-Trafficking Convention and the CHR? The primary means by which he sought to downplay the significance of the Anti-Trafficking Convention was to portray the core or headline Article 4 obligations identified in Rantsev as simply being a mirror and being intended to be a mirror of the well-established analogous obligations, he said, which arise under Articles 2 and 3. And he said, given that, no need to look at any external source, anything beyond Articles 2 and 3 and the passages in Rantsev itself to understand what the content of the Article 4 obligations might be. He also said there was no good reason for any significant difference between the Article 4 obligations and their equivalent in Articles 2 and 3. We say that that is the wrong analysis for 6 reasons. First of all, the origin of the Article 4 obligations, as is apparent from Rantsev, the court did not simply say we have similar obligations under Articles 2 and 3. Article 4 is equally important, therefore we ought to do the same here. What it said was that there was a need for Article 4 to require contracting states to put in place a comprehensive scheme to deal with a very serious problem of the modern era, as now understood through the Palermo Protocol and the Anti-Trafficking Convention. So it was the problem of trafficking as identified and explained in those 2 international instruments which gave rise to the Rantsev obligations, not simply that they ought to be a mirror of Articles 2 and 3. Secondly, that reflects in itself that the nature of the problem under Article 4 in relation to trafficking is very different from the problem or problems which the equivalent obligations under Articles 2 and 3 are intended to address. Articles 2 and 3 deal, in the main, almost entirely, one would hope, with isolated instances, all serious, no doubt, but confined in their individual facts. The phenomenon of trafficking, on the other hand, is different. It is, as the court explained, a global problem which will take place across several states and affecting thousands, if not tens of thousands of people at any one time. It would be surprising if exactly the same obligations were to apply to a phenomenon of that nature as the court has applied in the rather different context of Articles 2 and 3. Thirdly, the headline obligations identified in Rantsev are simply not the same, are not identified in the same way as they are under Articles 2 and 3. My Lady Hale picked up my learned friend on 286 of Rantsev, and the reference to credible suspicion, to there being a credible suspicion of that the individual had been or was at real and immediate risk of being trafficked, and you got the answer, well, there's a footnote that refers to Osman, and therefore it must have been intending the same thing as in Osman. But credible suspicion, that's that lower threshold, credible suspicion of real and immediate risk. Where does that come from? That comes from the Anti-Trafficking Convention. That's the trigger in that convention for protective and other steps to be taken. That is why there is a difference in the language of the headline obligation under Article 4 as compared to the way it's put under Articles 2 and 3. And that is a good example of how the Anti-Trafficking Convention influences the content of Article 4. Fourthly, the headline obligations derived from Rantsev are identified differently in Article 4 cases subsequent to Rantsev. And I'll just give you an example of that very quickly. In J and Austria, Bundle 1, Tab 10, at paragraph 109, which you have on MS 251, having recited the principles from Rantsev and some other cases, 109, the court considers the instant case essentially raises two questions: whether the Austrian authorities complied with their positive obligation to identify and support the applicants as potential victims of human trafficking, and whether they fulfilled their positive obligation to investigate the alleged crimes. And the finding that the applicants had been identified, protected, and supported as potential victims is at the top of MS 252. So that support obligation one simply doesn't see in the Articles 2 and 3 case law, and there's a very good reason why it's essential to Article 4. Fifthly, to the extent that there is an overlap, there is a significant overlap in the language of Rantsev as compared to the Articles 2 and 3 obligations, the same words don't fall to be applied in the same way under Article 4. So take the criterion of real and immediate risk. We know from the Court of Appeal decision in TDT, that's Bundle 1, Tab 6, paragraph 39 to 42, MS 134, we know from that case that real and immediate risk falls to be applied in a very specific way in human trafficking cases, and the court will assume, and the Secretary of State will assume, that somebody who has been trafficked in the past will usually be at real and immediate risk of being trafficked in the future. Not always, but there's a presumption at least that trafficking in the past creates that real and immediate risk in the future, and that's just an example of an application of the same words as one sees under Article 2 and 3, but in the particular context of human trafficking under Article 4. Sixthly, the specific applications of Article 4, which we have seen in the cases today, are very far from the reliance upon other international instruments, which Mr. Eady said this was a run-of-the-mill example of. It is not simply DEMIR, it is not simply referring to other relevant instruments. It is referring to specific duties under the Anti-Trafficking Convention in order to find a breach of Article 4. examples, Rantsev, obligation under the Anti-Trafficking Convention to provide trained persons to identify victims, led directly to the finding that the Cypriot authorities had breached their Article 4 obligation. Chowdhury, operational measures under Article 4, paragraph 110, are described in the terms set out in the Anti-Trafficking Convention. That is the yardstick set up by the court and leads to the finding at paragraph 115 that the Greek measures were not sufficient. The rest and recovery period leading to the breach of the duty to investigate, paragraph 121 of Chowdhury, and paragraph 126, which Sir James didn't refer to, it's perhaps the most difficult for his case. Paragraph 126, specific reference to Article 15 of the Anti-Trafficking Convention, providing for victims to receive compensation.
What's the page number for that, please?
MS 218.
318.
218, paragraph 126. And you see, first sentence, the facts of the case, only €43 per injured worker ordered to be paid. However, Article 15 of the Anti-Trafficking Convention obliges contracting states to provide for the right of victims to receive compensation. Para 127, therefore, a violation. So these are examples of direct reliance upon the Anti-Trafficking Convention that goes well beyond the normal demure situation, and understandably so, where the Anti-Trafficking Convention is the fons et origo of the Article 4 obligations.
Well, in fact, in these instances, is the court transposing the ATC directly into its consideration of Article 4?
Well, that's the most. That's the best example, I think, of that. There are other examples. One can debate perhaps whether it's directly transposing or it's adopting the approach to which my Lord Briggs referred to, where it's where the court has to decide what would or would not be proportionate in the circumstances, and it looks at the Anti-Trafficking Convention as a yardstick.
Well, all of these formulations are potentially slippery. I mean, whether it's informing the content or directly transposing and so on. But essentially, your submission, as I've understood it, is that Article 4 calls for a bespoke approach, and the only way in which that can be achieved is by having to the front of one's mind the various elements of the ATC, so as to ensure that none is neglected in the consideration of whether Article 4 has been breached.
Yes, I do stop short, as I've indicated, of saying that there's a direct transposition every single provision. But yes, one certainly does have to have the bespoke provisions of the Anti-Trafficking Convention in mind when devising, when identifying the bespoke scheme of Article 4. Yes.
I suppose there will be cases where some elements of the ATC will be more important or less important, depending on the particular circumstances of the case.
Yes.
But there needs to be, if I've understood your submission correctly, there needs to be an examination of those particular provisions so as to ensure that there has been compliance with whatever the duties of Article 4 informed as, or by consideration, or if not transposed by, but at least with the considerations of the ATC in mind.
Yes.
Yeah.
Yes, and perhaps to put it perhaps the other way around, if there hasn't been compliance with the ATC, why should that not be, in the particular case, a breach of one of the headline investigative, protective and so forth duties under Article 4, when these are all measures to which the UK and other states are committed on the international level. So, no automatic read across, but I did make the submission in my opening that breach of one of the core obligations of the Anti-Trafficking Convention, which I identified as 10, 12, 13, 14 and 23, will usually constitute a breach of Article 4. Can I just give you some references to the intervener's cases that go into a little bit more detail on that question? Our case, paragraph 41, MS 2310, and the Air Centre and ECPAT cases, paragraphs 54 to 57, MS 2350. Now, just a couple of then specific examples of provisions of the Anti-Trafficking Convention and how they might impact upon Article 4. The Article 12 obligation to provide support and assistance to victims. Sir James was particularly concerned to reject the suggestion that a failure to provide the support which the UK has agreed to provide under Article 12 should lead to a finding of breach of Article 4, or that there was any Article 4 obligation to provide that support. We say he was wrong to reject that proposition. I've shown you the reference in J and Austria to the headline Article 4 obligation being to protect and support victims and potential victims. We'd also make the point that support for victims is intimately connected with the duties under Article 4 which Sir James does accept. So, for example, the investigative duty, and there's a concrete example of that in the Strasbourg cases. I'll just give you the reference. SM and Croatia, bundle 4, tab 45, paragraph 69 to 72, beginning at MS 1391, the court examined specifically whether appropriate support was given to the applicant during the process of investigation and prosecution of the person who had exploited her. Support will also go to the protective duty, the duty to protect victims and potential victims of traffickers, because the objective of the support is to enable them to recover and escape on a permanent basis the influence of the traffickers. Now, I can't say, wouldn't say that any failure to give any of the Article 12 support equals breach of the protective duty, but it is not simply as the Secretary of State would have it, that there's a duty to protect from the traffickers. The traffickers are nowhere in sight, or they haven't been involved for the last few months. Therefore, there can't be any duty to provide support either. This is a comprehensive package to protect, support victims of trafficking, to enable them to escape from their predicament on a long-term basis, and that is, we say, part of the Article 4 protective investigative duties. The other specific example, which I want to come back on, mentioned by the Secretary of State, is Article 13, the recovery and reflection period, and the submission was made that if an individual is removed during or before they've been provided with a rest and recovery period, that could not be any breach of Article 4. Now, the rest and recovery period is one in which the individual is entitled to the Article 12 support. So all the points I've just made about the Article 12 support being significant apply there as well. But there is also a specific right in Article 13.1 not to be removed during the recovery and reflection period, which is essential for the protection, essential for the support of the victim. So again, there may well be a breach of the Article 4 protective investigative obligations if there is removal before that very important recovery and reflection period has been afforded. Can I then turn to briefly the Court of Appeal in Huang and Min, which my learned friend made some detailed submissions on. I only wanted to come back on one particular paragraph. It's Bundle 1, Tab 8. And it's paragraph 30 at MS 176. And you were you were provided with detailed submissions as to why the Court of Appeal was right in distinguishing the Anti-Trafficking Convention on the one hand and Article 4 on the other. Paragraph 30, the Court of Appeal says the Anti-Trafficking Convention has a wider scope. It is concerned with the immediate treatment to be accorded to those in respect of whom there are reasonable grounds to believe that they are victims of trafficking. Well, yes, it is, but not just that. It is concerned with providing them with assistance and support over the longer term, and indeed requiring the investigation and prosecution of offences, just as is Article 4. It's also concerned with their medium-term treatment for immigration purposes in the event that it's accepted administratively that they have been trafficked. Well, it is, but so is Article 4. If an individual is removed before any effective investigation can take place, that will, as in the present case, lead to a breach of Article 4. It's also concerned with the criminalisation of behaviour associated with trafficking and the need to investigate and prosecute offences. Well, so is Article 4. And I don't think there is any disagreement between us that the competent authority is not the only means by which the UK state complies with the Anti-Trafficking Convention, or indeed with Article 4, but mistakes made along the way by the competent authority can be very significant in then causing the individual not to receive the Article 4 protections which they are due. The final area that I want to deal with, by way of reply, is the investigative duty in the present case and the finding of the upper tribunal that there was a breach, that the removal decision breached the investigative duty because no effective investigation would be possible if MS was removed to Pakistan. Now, one of the questions which the Secretary of State should have asked herself when taking the removal decision was, would removal of MS frustrate an effective investigation into the human trafficking offences which occurred in his case? Now, of course, that wasn't considered because the Secretary of State didn't think that there was any issue of human trafficking in MS's case. But it is clear, and we know from Article 4 and from the Anti-Trafficking Convention, that the consideration of whether or not there has been trafficking does not depend on a complaint by the victim, either before the Secretary of State or indeed later before the tribunal. that is a matter which must be investigated in any event. In the present case, the list of issues to which my learned friend referred when the case came to the upper tribunal did include Article 14 of the Anti-Trafficking Convention. You've seen it already, but it's paragraph 9, Roman 4 on MS 2395. One of the obligations referred to was Article 14, which of course contains the obligation to provide a residence permit to enable cooperation with an investigation.
Just give me that page number again, please.
2395.
Thank you.
And we understand that the written arguments, we've spoken to MS's advisors about this, the written arguments to the upper tribunal did refer to the investigative obligation. But the evidence before the tribunal was that there had been no such investigation. Sir James says, well, we can't expect the Secretary of State to consult with the police as to whether there has been an investigation. Well, why not? It is an obligation of the United Kingdom not to remove if an effective investigation hasn't taken place. If that means that the Secretary of State needs to speak to the border agency or to a particular police force, then so be it. This isn't chasing shadows, as my learned friend put it. I do agree with him that in any particular case, for there to be a breach of Article 4, removal would have to prevent an effective investigation. That's what he said. That's a current question when the case comes before the tribunal, and it's a question which must be determined by the tribunal on the facts which it finds on that day. I agree with all of that, but none of that leads to the conclusion that this is an exceptional situation, that it's only in exceptional cases that the tribunal could find that an effective investigation has not yet taken place and would be frustrated by removal. And we say the upper tribunal was perfectly entitled on the evidence to make that finding in this case. And the Court of Appeal's ruling in paragraph 88, which my learned friend referred, we say is plainly erroneous. It didn't ask the right question and it gave the wrong answer to the question which it asked with respect. And unless I can assist further, those are my submissions.
They're not looking full of questions for you, Mr.
No.
Oh, no. Thank you very much. Thank you. Well, thank you all. We were, of course, very grateful to the Commission for wishing to take over the appellant's arguments in this case, principally because of the main issue, which is now a subject of concession by the Secretary of State. But it has enabled the investigation of a rather wider set of issues, and we'll have to go away and think what we can usefully contribute to the resolution of those issues. So thank you all very much indeed, and we will let you know the fruits of our labours in due course.